A class action lawsuit against Uber, which claims drivers should be classified as employees and receive benefits, will now proceed in Ontario. There's a clause in the contract all Uber drivers must sign. It states that any disputes brought against the company must go through arbitration in the Netherlands. The Ontario Court of Appeal ruled that was illegal, saying Uber chose the clause in order, quote, to favor itself and thus take advantage of its drivers. So joining us this morning is employment lawyer Kumail Karimji, partner at Toronto's Karimji Green Law Firm. Thanks so much for coming in.
Pleasure to be here.
Okay, so let's get right down to this. The lawsuit claims Uber drivers are currently classified as contractors, but should be classified as employees. Under the Ontario Employment Standards Act, that would entitle them to things like minimum wage, overtime pay, parental leave, and termination guarantees. So, Kumail, what will the courts look at to determine whether or not Uber drivers should be classified as employees or contractors?
There are a number of factors that a court looks at in assessing whether or not an individual worker is an employee or an independent contractor. It's really a question of whether or not the driver, or the person claiming to be an employee, is in a business of their own or alternatively a part of the company's business. The factors include whether or not there's a risk of profit or loss, who owns the tools, and really who has control over the work, the methods of work, how it's done, where and when.
Okay, so there are similar lawsuits against Uber tied up in the U.S. courts right now. Also in the U.K., a London judge ruled in December that Uber drivers are employees, though Uber has appealed that ruling. So how does Ontario's case play into all of this?
Well, I think this case will be watched closely, not just in Canada, but also in other jurisdictions. There are cases, a number of cases, in fact, about 4 that I'm aware of in different jurisdictions in the U.S. as well as in the U.K., and while a case in Ontario would not be determinative on other jurisdictions, I think it will be of interest in those other places to see how our courts grapple with this problem.
Well, and I imagine of interest right across our country.
Of course, absolutely.
So Uber is part of the so-called gig economy where people work independently, but a company controls that work. This is something kind of new in Canada and right across the world. Other examples include vacation rentals, food delivery services. How do our labor laws handle something that's brand new? Do they need to be adjusted or updated or evolve?
That's a very good question. Arguably, there's a gap. Our labor and employment laws were designed for a different era, for a different economy. And I think jurisdictions like Ontario and others around the world are looking at how to catch our laws up with this new reality. As technology changes the way we work and how we work, and the nature of our relationships with our paymasters, how is it that our laws can address that? And really, at the moment, I think what we have is a bit of a gap, and there's a question about not just case law and cases working their way through the courts, but also law reform in a bigger sense about how to catch the laws up and ensure that workers have the protections that they should have when working under a new model.
And that's not something that happens overnight. This is a process that will take years to get there.
Yeah. Absolutely.
Kumail, thanks so much for being here.
Thank you very much for having me.